Okay, welcome and good morning, good afternoon, good evening, everyone. I'm Hannah Shea, World Law Group's Manager of Communications and Network Development. Thank you all for joining us on today's webinar on the proposed e-regulation on artificial intelligence. Before we jump into the topic, I did want to give a quick overview of World Law Group for those of you who may not be familiar with our network. We are a leading network of independent law firms across the globe with 61 member firms and more than 21,000 lawyers in our network. We collaborate globally through our 17 practice and industry groups, and in 2020 shared almost 3,500 referrals among our member firms. Just a few housekeeping items. You have been all muted and you will remain muted throughout the duration of the webinar. We will have time for questions at the end, and I ask that you please use the Q&A feature throughout, and we will moderate those with our panelists at the end. You can ask them anonymously by checking the anonymous box if you prefer to do so. I will now hand this over to our moderator and the Artificial Intelligence Group co-chair for World Law Group, Johannes Juranek of CMS Austria, to introduce our panel.
Thank you very much, Hannah. I'm Johannes Juranek. I'm managing partner of CMS in Austria, and I'm also heading our department for IT and data protection law. And it is my honor to moderate and chair this meeting today, where we are going to talk about the proposed European Union regulation on artificial intelligence. And it is my honor to introduce the panel of our specialists today who are going to discuss with me and you. First of all, welcome Adaya Esteban from Cuatrecasas, I hope I pronounced that correctly, law firm in Spain. Adaya does IP, privacy, and new technologies. She is an associate lawyer in the Spanish law firm Cuatrecasas for the past 4 years. She is specialized in privacy, e-commerce, software, technology transactions, and artificial intelligence, as well as automated decisions. She's member of the Spanish New Tech Commission within the Association of Women in the Legal World, the global by invitation only top talent network, Nova Talent, and the Spanish Association specialized in artificial intelligence. And she is the winner of the Nova 111 list. Furthermore, from Cuatrecasas as well, Alejandro Negro, as well, IP, privacy, and new technologies, of counsel in the Spanish law firm Cuatrecasas, specialized in IP, privacy, new technologies, including software and technology transaction. Moreover, Alejandro is lecturer in many Spanish universities' master's degrees. From Finland, I may welcome Kim Parvainen from Castren. Kim works in intellectual property and digital matters. In particular, he focuses on regulatory issues and litigation in the digital space. He routinely acts for clients in complicated intellectual property, data protection, and technology-related project disputes. He represents clients in litigation before both national and European courts and arbitral tribunals, as well as in a range of regulatory proceedings. He is also frequently asked by clients to draft and negotiate complex commercial contracts. And furthermore, Brian McElligott from MHC. Brian is a partner in the intellectual property and artificial intelligence team in Mason Haynes & Curran, one of Ireland's largest firms. He advises clients from a range of sectors, including telecommunications, food, beverage, energy, agriculture, pharma, medtech, and e-health, on the formulation and implementation of effective commercial and IP development and protection strategies. He is registered in the Irish and European Union Trademark and Design Agent for former chair of the Licensing Executive Society of Ireland and the Irish branch of the Anti-Counterfeiting Group. Brian has a particular interest in artificial intelligence, and he is spearheading Mason & Haynes and Current's innovation in this space. So welcome very much. I'm trying to share my screen now because I would like to give you an overview of the draft at hand, and we'll give you just a brief introduction into the matter, and then we will be able to discuss with our panel. The European Commission proposed the first ever legal framework on artificial intelligence, which addresses the risks of artificial intelligence and the positions Europe to play a leading role globally. This was issued in April 21st, 2021. So you can see this is a very recent draft. I have to emphasize it is a draft. We are not talking about a regulation yet. The model it follows is the so-called NFL regulation, which stands for New Legislative Framework Regulation, which establishes a number of requirements and objectives which the system needs to meet, but the regulation does not govern technical details that need to be obeyed. The proposal is part of the European Commission's larger European strategy for data, which seeks to defend and promote European values and right in how we design, make, and deploy technology in the economy. This proposal is accompanied by the so-called Coordinated Plan on Artificial Intelligence 2021 review. What is remarkable is that the draft provides for severe penalties like GDPR, like the General Data Protection Regulation, but is in part exceeding the amount of the penalties provided in the GDPR. So when is this proposal or the future regulation applicable? Providers who market in the European Union or put artificial intelligence systems into the service in the European Union, as well as the users of artificial intelligence systems in the European Union, including governmental authorities located inside the European Union, shall be covered. Furthermore, providers and users of artificial intelligence systems whose output is used within the European Union, even if the producer or user is located outside of the European Union. So here you can say there is an extraterritorial application similar to what GDPR provides. This proposal would particularly affect so-called high-risk AI system providers, as they are currently not subject to a detailed compliance review under existing European product regulations, but they would be under the new artificial intelligence regulation. Sorry that this jumps a little bit. So the proposal for the regulation on artificial intelligence provides for a large scope. I'm quoting, "The scope is software that is developed with one or more of the techniques and approaches listed in Annex 1 of the draft and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, influencing the environments they interact with." This definition is broader than what is currently viewed as artificial intelligence. And this regulation could also cover e-commerce or social media platforms. The proposal is subject to lawmakers that can revise the definition of artificial intelligence systems. The definition may still be adapted further in the process. So the European Union so far is not finished with these definitions. The regulation is going to follow a so-called risk-based approach, whereby I have to state that the Commission is basically of the opinion that the technology is beneficial and can be used, but only under certain circumstances and under certain conditions and regulations. Again, as pointed out already at the beginning, the NFL approach says that the draft does not govern the technology itself, but only the use cases. And what I'm showing you now is a pyramid which shows the various levels of risk. On the top, we see the so-called unacceptable risks, for example, social scoring. This is what the regulation basically prohibits because it considers this as being a non-acceptable risk. The largest part of the applicability will be what we call the high risk level. We are speaking here of recruitment tools, of medical devices, and so forth. These kind of applications will be permitted, but they will be subject to comply with certain AI requirements, and the users or the producers respectively shall conduct so-called conformity assessments. And this is a very important point to which we will come later. The next level is what we call transparency risk. We are speaking of impersonation tools, of bots, and so forth. These kind of tools shall be permitted, but subject to information and transparency obligations. They will require disclosure. And then the last level is minimal or no risk. This shall be basically permitted without any restrictions, and such applications are not really affected by the regulations, and we are speaking about spam filters, applications in factories to optimize procedures, engine control tools, and so forth. The draft also contains a definition of certain risks. We are speaking of two major blocks of risks. On the one hand, we are speaking of safety risks, such as death, injury to a person, and damage to property. And furthermore, we are speaking about the second block, including fundamental rights, such as discrimination, manipulation, exploitation, or the lack of control. So you can see that both blocks are equally addressed by this draft, and both consider a risk that needs to be assessed and regarded when using artificial intelligence. First group are the completely prohibited artificial intelligence systems, which was the first layer of the graphic I showed you previously. The applications are capable of inflicting physical or psychological harm resulting from subliminal techniques or exploiting the vulnerability of a group of people, for example, due to their age or any limitations. And they manipulate their behavior in an unnoticed way. The second group, the partially prohibited artificial intelligence systems, are systems like social scoring, for example, or real-time biometric identification systems. Social scoring applications evaluate the behavior or characteristics of people based on points if public authorities or others on their behalf use social scoring, and this seems disproportionate, or the findings are used in a context other than the one in which the data was collected. So I'm thinking about systems where governments, for example, rate and score the behavior of people. The real-time biometric identification systems in public spaces for the purposes of law enforcement, for example, to find missing victims of crime, to prevent serious and imminent danger of human life or public safety, or a terrorist attack, for example, or to track down criminals whose offenses are punishable by a maximum sentence of at least 3 years. Except in cases of imminent danger, prior permission of a judge or an independent authority, these measures are prohibited. But if the requirements which I just outlined to you prevail, then under certain circumstances, when the judge or an independent authority has agreed, such measures can be applied. The two blocks of risks, damage to property and damage to the human body, and discrimination and fundamental rights on the other hand. The systems which intend to be used as safety components of products that are already regulated under existing product safety laws, such as machinery, toys, or medical services, will be subject to an independent third-party conformity assessment. In other words, we are speaking about artificial intelligence, which is included in pre-existing products. Imagine a computer tomograph, for example, or diagnosis devices, self-driving cars, toys, etc. In all these applications, artificial intelligence will play a role, but they are included in the product. And here you will need a conformity assessment, most likely to be implemented, provided by third parties, by authorities or certain institutions, which shall clear and make the product legal, such as medical authorities, for example. In my country, medical devices shall be cleared by the Ministry of Health, for example. So also in this case, the artificial intelligence, which is included in the product, must be cleared by these authorities. And then you have a second block, certain standalone artificial intelligence systems. They are not included in a pre-existing product. They are not a component of such a product. The areas listed on the slide below are provided by the draft. It's about biometric identification and the categorization of natural persons, management and operation of critical infrastructure, education and vocational training, employment and workers management, access to self-employment, access to and enjoyment of essential private services and public services and benefits, law enforcement, migration, asylum, border control management, administration of justice and democratic processes. So the draft mentions certain use cases under each area, which is listed in Annex 3 of the draft, and these use cases will be updated from time to time. The areas which I just read to you will not be updated. They can only be changed and modified by a legislative decision. So you need to be aware that we are speaking about work in progress. So what are the requirements for applying high-risk artificial intelligence systems? We need to establish and implement a risk management in the light of the intended purpose of the AI system, such as high-quality training, validation, testing data, technical documentation and logging capabilities, appropriate degree of transparency, and providing users with information on capacities and limitations of the system. There needs to be a human oversight, and the robustness, accuracy, and cybersecurity needs to be guaranteed. The NFL approach allows flexibility for the producers. The compliance with the provisions of the regulation shall be achieved by a risk management system implemented by the provider. And now, after this short overview, I would like to welcome the panel, which I've introduced today. I will stop sharing the screen now and go into the discussion. So I would like to address the procedural requirements and open the discussion now. And first ask a question to my colleague, Brian McElligott. Brian, can you explain us something about the procedural requirements and what requirements we are actually speaking about?
Yes, thanks very much, Johannes, and hello everybody. I'm delighted to be here today. As you had on your last slide there are 7 requirements, and to recap, the requirements relate to this category of AI, which is called high risk. Now, with the time given to us, I don't propose to go down through each in turn, but what I think might be a good thing to do is to take you through an example of how these requirements might look in practice. The example I've selected here will be a software tool that can automate the candidate selection process as part of recruitment, and recruitment and employment is identified as one of those high-risk sectors. Now, before I can ever put that on the market, I got to satisfy myself of some of the following requirements. First up, let's assume my recruitment tool is based on some form of machine learning trained on a data set, and it's based on CVs or resumes. The requirements will compel me to make sure that those CVs and resumes represent a broad enough diversity of data to be relevant, representative, free of errors, and complete, and must be appropriate for the intended users or groups of users. You know, what we have here is that, I can't just go along and select a bunch of CVs for a software job where it's a bunch of white middle-aged males. And indeed, that was the reason why a very well-known large tech company with a project in this area had to scrap a very expensive project. I must also give thought about and specify the exact use of the product and consider what it might foreseeably be misused for. Further, I must consider what those risks are and eliminate or mitigate as best as possible that risk. So when I'm preparing my product under these proposals, I've got to think about what someone might misuse my product for. Will they try to use my recruitment tool to discriminate? And I've got to try and mitigate that risk technically. I've got to also ensure that the recruitment tool is subject to human checks and human oversight. To do this then, I suppose I'd have to design it so that the user fully understands the capacities and limitations of the tool, and they are able to use that information to intervene in an appropriate manner, a sort of a kill switch or a stop button. I've got to also design the tool to an appropriate level of accuracy, robustness, and cybersecurity, which I then have to declare to the user in my instructions on how to use the tool. Not only that, but I must also ensure that the tool will perform consistently with those levels that I have put into my instructions throughout the life cycle of the product. And finally then, from the very outset, I've got to record how my tool complies with the requirements. And I have that record ready if and when I need to demonstrate compliance to an AI regulator. Also, the tool itself must be designed and developed with capabilities enabling it to record certain events. Again, if the investigations or if a regulator comes knocking. So that's just kind of a very high level oversight of how things might work in practice. And you can see it's quite onerous, Johannes.
Yeah, just an additional question to you, Brian. I've outlined in my short presentation that we are speaking about artificial intelligence tools which are included in pre-existing machinery and so-called standalone solutions. So your example, would that qualify as a standalone solution, or would it be implemented into a machine?
It could be both, really. I guess in the most standard example, it would be standalone. It would be a software project delivered to a company for screening candidates. Mm-hmm. So most likely standalone, I'd say.
Yeah. So that would actually require then a conformity assessment to be provided by the producer itself. Is that correct?
Yeah, and they would have to be able to do that assessment themselves and stand over it and keep the paperwork from that assessment if ever the regulator.
Okay. So what are the obligations of the producers and the users of artificial intelligence? We have briefly spoken about that in the short intro. But Kim, can you maybe tell us a little more about the obligations?
Yeah, sure. I mean, in terms of these procedural, where there are these sort of substantive requirements, like Brian mentioned, but also these, I think, like you mentioned, procedural obligations, let's call them, where, I mean, familiarly from those who work with, the European General Data Protection Regulation, there are all these sort of documentations. Even if you're compliant, you're not compliant until you've written down on a paper why you're compliant, which is one thing. And then that's maybe from, well, the GDPR world. But then the other aspect, which is, I think, pretty interesting here, is you mentioned this sort of new style legislation, which is funny because I think it's been called new style legislation since the 80s, where the idea is that these sort of high level requirements that Brian mentioned that you need to go over, you need to do a conformity assessment of them, and then that conformity assessment sort of, I think those of us who live in Europe are familiar with the CE logo that's stamped on all our electronics essentially, and then there's in the manual a declaration of conformity where the producer, for instance, or the importer has to sort of declare that this is conformant. But the sort of procedure to get from those requirements to actually being allowed to put the stamp on your product is familiar, I think, to those who are in broad outline anyway, familiar to those who have worked with like product safety regulation, because there we have the same sort of new style idea that the regulation itself will contain fairly high level requirements. And then there's a rule in the regulation says that if you comply with sort of non-statutory standards, you are presumed to comply with these sort of general requirements in the European or in this regulation. So the idea is that I guess the European Committee for Standardization, CEN or CENELEC or something like that, will develop standards that sort of develop these high-level requirements. And then depending on the nature of your product, which I think is the point of criticism here, it's quite fine-grained. You talked about like high-level and low-level and prohibited systems, but actually even high-risk systems then have their own subcategories, which are not entirely clear if you read the draft, which just goes where. So then depending on which sort of sub-bracket you fall into, you can either do this conformity assessment yourself, and then you get to use the stamp and declare your conformity, or for some other systems, you need to go to what's called a notified body, which are then these sort of authorized testing laboratories, let's call them laboratories, will then review certain documentation requirements and the product to some extent, and then say, okay, fine, now I, as the notified body, certify that you're compliant, and then you get to put the stamp on. So there's, like Brian mentioned, there's a lot of substantive requirements, but I think there's also a fair bit of procedural requirements or obligations in terms of how you need to translate those substantive requirements into ultimately that stamp that is very familiar to Europeans.
Yeah, we have to say also, and I think everybody on the panel will agree with me, that this is a really complicated piece of work, a piece of law. It's not easy literature, let's put it this way. So it really means working with this draft in order to fully understand it. And as you pointed out, rightfully, it's very complicated. It is. But Alejandro, maybe we can speak a little bit about the compliance aspect. And I would like to ask you what we've discussed so far means from a compliance point of view.
Thank you, Johannes. This new European framework regulation for artificial intelligence is based on the increasingly widespread risk-based and accountability principle. As you know, those principles place the burden of proof on the corporate that must be able to provide evidence when the system is compliant with the mandatory requirements and obligations previously mentioned by Brian and Kim, and whether it is certified under this proposal. Okay, those principles have been already applied in different sectors, for example, in data protection, from the entrance of the GDPR by means of the risk-based assessments. In artificial intelligence, this compliance would be achieved, for example, in high-risk artificial intelligence systems through a comprehensive ex-ante internal control checks by the providers, combined with a strong ex-post enforcement, okay? When we are talking about the artificial intelligence systems intended to be used as safety components of products that are regulated, for example, when we are talking about toys or medical devices, these systems would be subject to the same ex-ante and ex-post compliance and enforcement mechanisms of those products, of what they are components. And this mechanism will ensure compliance not only with the requirements established in the sectorial legislation, but also in the requirements of this new proposal, okay? If we are talking about the so-called standalone high-risk artificial intelligence systems, mentioned it in the Annex 3 that you have saw before, okay? I think that the new compliance and enforcement system is established in this proposal by means also of an internal controls checks carried out by the providers, with the only exception of the remote biometric identification systems that would be subject to also to a third-party conformity assessment. Honestly, I believe that a comprehensive ex-ante conformity assessment through internal checks combined with a strong ex-post enforcement could be an effective solution for this kind of systems. It's clear that this artificial intelligence is very innovative and honestly, a real expertise in auditing this technology does not yet exist. I think that we will have people ready for that in the future, but not now. And regarding the compliance, obviously, I think that Kim has already mentioned it. The provided would also need to draw up a writing EU declaration, and also we will need to retain and keep at the disposal of the competent national authority different documents and different documents for a long period of time, for 10 years, like the technical documentation, the documentation concerning the quality management system, documentation considering the decisions and changes approved by the notified body, and obviously the EU declaration of conformity. I think that this compliance regime means a more relevant role of the internal compliance teams in the company. They are subject to more duties and obligations, and obviously this will increase lawyers' work in the future. I'm sure about that. So for all of us, for all the panelists and for all the attendees, I think that this will be plenty of work in the future.
Thank you, Alejandro. There are, of course, always two sides of the coin. One is us, the lawyers, who may enjoy a lot of work in the future, but on the other hand, you have the side of the users and producers, and maybe we as lawyers will use artificial intelligence as well, and then in our law firm, such systems will be implemented and we become users. So what I'm reading out of the draft and what I heard today in your presentations also is we are talking about a lot of compliance, a lot of conformity assessments, either by third parties or self-assessments, so forth. And if you actually perform a self conformity assessment, you need knowledgeable people and so forth. Isn't that a really excessive administrative and in particular cost burden, Brian?
Absolutely. I guess the degree to which it will be very expensive or excessive will only be known in time, and it's speculative for the moment. But if you just take, let's say, the example I gave of the AI recruitment tool, think about all the requirements I was talking about, think about everything Alejandro and Kim were also talking about on the compliance side, and the key point about everything needing to be done before the product is complete leads to the natural conclusion that day one, when I sit down to plan my product, I've got to plan it with AI regulation in mind. It's like the, you know, privacy by design concept. It's going to be AI by design concept. And to Alejandro's point, in order to achieve that, I need the expertise at the table when I'm planning my product to implement that. And not only do I need that expertise, but it's new expertise because it doesn't exist at the moment. So these are completely new roles. AI regulatory experts need to upskill and become involved in all of this. And not only that, but they have to sit down with the engineers and make the engineers understand what it is required. And there needs to be a dialogue with the engineers to say, well, I needed to do this. And the engineer will say, well, I can't do that. And then you have to go, well, I need to get the next best thing, because as Kim and Alejandro were saying, it's a risk-based assessment. So if you take that in the round, I think absolutely there will be certain product owners who will be scratching their heads and thinking, how am I going to meet these standards? And how many new people am I going to recruit? And more importantly, where am I going to get these people if they don't yet exist?
And do you think that means that maybe startups producing artificial intelligence and providers will look for different markets than the European Union? Can they go somewhere else where they can avoid it? And maybe that's a question I would like to ask Adaya, because as I mentioned in my presentation, there's an extraterritorial reach of this draft regulation. And so my question is, will it be possible in the future to just not market this in the European Union and do it from somewhere else, like sitting in the United States and applying your artificial intelligence there? And the second question I would like to ask you, Adaya, is what happens if I don't comply with what was previously discussed?
Well, as you have introduced, it is relevant to highlight that the scope of application of this regulation, of this proposed regulation, is very broad and comprises, well, all actors within the value chain of the artificial intelligence system, which includes providers, product manufacturers, importers, distributors, and also this covers authorized systems placed on the market or used in the European Union, but also those located in third countries, where to the extent that the output produced by these systems is used in the European Union. That means, as you have mentioned, it's extraterritorial effects that go beyond the European Union and very similar to the data protection regulation and what happens to GDPR. For me, I for one believe that this seems quite logic, considering all the globalization and internationalization. New technologies and systems are deployed nowadays in several countries at the same time, while keeping the core headquarters on the other side of the world. So we need general regulations that are applicable in many countries. So to answer your question, I don't think that this will mean companies just deploy their artificial intelligence systems in other countries, because well, the market is Europe, and Europe is the leading one regulating this kind of technology. So, well,
what you're saying is basically, even if I sit in the United States, but I apply the system on the European market by doing business in Europe and using the software in Europe, despite the fact that I have no corporate residence there, would make me subject to the regulation. I think that's a very important information. But if we now talk a little bit about breaching the regulation, because my impression is it's very easy to breach it, as much as it's very easy to breach GDPR, because there are a lot of undefined expressions and you can always oversee something. Things can happen. So what is the consequence if you breach? What kind of penalties does the regulation provide?
Well, this can be quite scary to be true. I mean, as you have introduced, the fines are really similar to those related to data protection. So according to this draft, and depending on the obligation in France, what the operators can be subject to really high administrative fines of up to 30 million euros or 6% of its total worldwide annual turnover, which is high as usual. Whenever it talks about non-compliance with the provision of artificial intelligence practices that are prohibited, or not compliance with the high-risk artificial intelligence system obligation with regards to data governance, and in particular, which refers to training and validation and testing of data. When we talk about other non-compliance to other non-requirements or obligation under this regulation, we have just seen that the operation shall be subject to administrative fines of up to 20 million euros, as we have in the GDPR, or up to 4% of the total worldwide annual turnover. And also, they have another type of sanction for the supply of incorrect or incomplete or misleading information to notify bodies, national competent authorities. And in this case, operators are subject even to fines up to 10 million euros or 2% of its total worldwide annual turnover. So as we can see, we are talking about really high sanctions that follow the same criteria as the data protection regulation, and the very same high quantities or even higher. That's surely, I think, what can create same fear as the GDPR did when it enters into force.
Yeah. Well, that sounds scaring, actually, not only because the penalties are so high, but because the draft is so complicated to read, and I believe it will be really difficult to read even for lawyers who are not really involved in this field. So, Brian, will this have an impact on new market entrants? Will this be disproportionate to impact that there will be larger artificial intelligence groups entering the market and sort of pushing away the smaller ones, because the smaller ones will be too scared to enter the market? And will that create new monopolies for the large ones who can afford the large infrastructure in order to comply with the really complicated provisions of this draft?
There certainly are some risks there, Johannes. I could give you maybe the view, let's say in Ireland, which is traditionally a very startup SME-based jurisdiction. My experience of dealing with a lot of the startups here in AI is that they are very well versed in things like, bias, ethics, transparency, and explainability. But to your point, they just don't have the resources to actually turn that knowledge into some form of compliance. And to step up then and to try to read, comprehend, and be compliant with some legislation like this is very, very challenging and requires a lot of money. With regard to the likes of new market entrants, I think as Adaya was saying there, the main driver, I believe, is the attractiveness of the EU jurisdiction and a population of 450 million people, even after Brexit. So I do believe that no matter what ends up being the law after all these proposals, we still have a very attractive offering here for the various product manufacturers. In general, I'd see it kind of breaking down into a number of sectors. I'd see the sophisticated existing medical device type businesses probably being quite easily coping with this sort of technology, because those guys have huge regulatory teams internally. Now they'll have to upskill them, but they're the best placed of all to take this on board. Then you have the likes of the other product providers who wouldn't be used to such a massive compliance, but they would be used to things like CE marking. Well, they're going to feel a bit of pain there also. Surprisingly, actually, the large tech companies might struggle a lot more than we think, because some of them are not at all used to complying with any heavy regulatory projects other than things like GDPR. Now, I know GDPR is heavy compliance in and of itself, but having to go before some sort of notice body isn't something that the large tech companies are used to. So they might struggle a bit there. We've already spoken about the SMEs. Maybe another way to look at it is that the guys, let's say you're like your traditional manufacturers of medical devices, they're probably not on the cutting edge of producing this AI in the first place. So they're probably going to partner, and they may partner with the SMEs or the startups. And under a model like that, it might be possible for the likes of those SMEs and startups to get the funding and the training and the resources they require. But to your point then, Johannes, does that mean that a lot of these guys get subsumed into larger companies and we see, I suppose, a skewing of the market? I don't know. There's a lot to be seen as things roll out.
Mm-hmm. Thank you. And Kim, question for you. But if we believe that the development would go in this direction, could this result in having a monopolizing or anti-competitive effect?
Well, I mean, yeah. I have to say I'm pretty skeptical about this. To sort of restate Brian's point is that it's going to be the incumbent players who are going to have an easier time complying with this. Although I will admit it's a very interesting point about how tech companies are not really used to this style of regulation. But I mean, one would assume it will mean, because I mean the way I think about like a lot of tech development is that there's this first stage, freedom to tinker. You have these bright guys and girls who tinker with something and come up with a product, and then if it's good, someone invests in it, and then it hits it big, hopefully. But when we sort of have this obverse approach of where you have all these compliance stuff that you need to do before you can tinker, there's the regulatory sandbox approach, but yeah, I wonder, will these startups really be able to sort of flourish, and will these sort of the side effect of that be, I don't know, monopolizing is maybe a strong word, but it will be the maybe big AI players who then can comply with this. One thing I'll just sort of touch on Brian's point, I guess it's a pretty, I won't pretend to be an expert, but I guess it's a pretty common model in like pharmaceuticals and maybe medical sector, where you'll have an innovative company who develops something, but they're not able to bring it to market because the compliance regulators are so onerous. So you start your company, you tinker, and then you sell it, which obviously has effects in terms of market concentration, which will be interesting to see how that works out.
Thank you. So we are 10 minutes before the hour, and Hannah, I guess it's time to take questions from the audience.
Johannes, you can go another 5 minutes. I've got just the one question for any of the panelists who want to take it regarding the statement published by the EDPB and the EDPS regarding the proposal this week, if somebody wanted to comment on that.
Is there anybody on the panel who wants to comment on that? I cannot, I have to say.
Yeah, I can comment. The EDPB and the EDPS has issued a joint press release this week. Okay, it's just 2 pages press release, but they are talking about several things. Okay, they were just saying hello. Artificial intelligence proposal. You have forgotten to talk about the GDPR, and you should know that the GDPR also applies to any artificial intelligence. Well, it's obvious. They have also mentioned it that the concept of risk to fundamental rights should have been aligned with the European Union data protection framework, because the definition is slightly different. They also mentioned that this framework should be a precondition for entering the European market as a CE market product, as we have mentioned it before. Okay. They would like to ban, to have a general ban on any use of artificial intelligence for automated recognition of human features in any publicly accessible space. For example, faces, DNA, voice, or other things. And they also they mentioned that that both bodies should consider that the use of artificial intelligence to interfere emotion of a natural person is highly undesirable and should be prohibited also. And the last point is that, as my first point, they are also asking for something, and what they are saying is that as the GDPR is involved in data processing, obviously, and the artificial intelligence systems also involve personal data, what they are saying is that the data protection agencies, the local data protection agency, should be the national supervisory authorities mentioned in this new proposal, okay, in order to harmonize and to have a regulatory approach that is really harmonized, okay? So at the end, more or less what they are saying is that this is very interesting and we would like to participate it very actively.
Alejandro, you mentioned the connection between GDPR and the AI regulation. So very often one reads that the AI regulation will be the GDPR of artificial intelligence. I mean, you have already highlighted the interdependence between these two, but would you agree if somebody said it's the GDPR of artificial intelligence? Is that something you could agree with?
Yes, absolutely. I think that this new framework promises to have the same profound impact on the use of the artificial intelligence as the GDPR has had on personal data. With both developers of high-risk artificial technologies and also for the users. I think that most of the laws normally are local, but I think that this is different in the digital sector, okay? Mm-hmm. And when the European Union comes up with some new tech regulation, I think that it quickly spreads around the world, because usually this regulation is quite strict, okay? Mm. And for global companies, it's easier to adopt the European regulation for their products and markets and different services for all the markets, instead of having to apply different legal frameworks, okay? Mm. And something that we have also seen with the GDPR is that other governments have taken much of our regulation to draft their own acts. This is what we call I read about the so-called Brussels effect of the European Union GDPR, okay? That now it has become a global standard. And I think that this is the reason why I was not surprised last week when everybody was looking at Brussels about this new proposal. I think that everybody, all the different countries, will follow probably the approach of the final draft whenever it comes.
Thank you. I would like to ask a question to the entire panel, and please feel free to contribute if you want. I also said at the beginning that this is only the first draft of the artificial intelligence regulation, and we still have quite a journey to go until this draft will reach the final state. So are there any considerations on what will stay and what will be changed in the current draft? Is there anybody who wants to answer this question? It's a difficult one, I know.
I'm too scared to answer the question, but I'd like to point out that it's an interesting, it won't be final even when it's final, because the annexes can still be changed after that, which I think will be an interesting point. You know, you're targeting one, I'm developing an AI system. I don't need to comply because I'm not in Annex 3, but then one day I wake up and find that I am in Annex 3. So that's also going to be a pretty big thing compared to some other regulatory things where you know, the legislative process is perhaps slightly more extensive. Not to say that amending the annexes is very easy itself, but still. But yeah, I would be too scared to actually give an answer to your actual question when
So
what will be dropped.
Thank you, Kim. I'm receiving questions from the audience now, and one question is regarding the list of crimes for which an exception would be taken for law enforcement and use of biometric artificial intelligence. Should the list be shortened, is the question. Is there anybody in the panel who wants to answer this question? If not, I would take the liberty. I think my answer is for the time being, no, we don't have experience. And I think considering my experiences with GDPR is that we are suffering from undefined expressions in regulations of that kind. So I think the more definitions you can give and the more clear statements you can provide, the easier it will be to execute. So from a logistic point of view, I'd rather say that the more you provide and the more you say, the easier it will be to execute. What I could consider is, from a political point of view, whether you would rather have less exceptions in order to make the entire or to make less exceptions, to make it more difficult to actually apply these kinds of artificial intelligence applications. That's what I can say to that. And
if I can add something, just
yeah.
I agree with you, Johannes, but I think in this particular case, the examples they have included, well, the examples, the list is kind of political, because some of the crimes they are saying is just the ones we are all saying, we are all seeing all the time on the TV. So I've heard, and I agree that some of this one part of this list is kind of political. It's just to, I don't know, but just to say that.
I have another question from Venezuela. How do you believe that the regulation will be enforced? Ex ante controls like licenses, or ex post as fines for breach and certain obligations? This is a good one, and I think we can also draw a parallel to GDPR. So is there somebody who would like to answer this question on the panel?
Well, I just,
No?
I will
Okay.
Sorry.
I believe that it will be ex post. What we also encounter with GDPR is that actually the burden of assessing whether your application is compliant with GDPR is something you need to do by yourself. So there's no authority to help you. And once you have implemented a tool or a procedure, you may be subject to scrutiny. And I have experienced a lot of cases where the data protection authority comes after you've done something, after you have implemented a system, and tells you it's not compliant. And the experience I made is, at least in Austria, which is my jurisdiction, that the data protection authority does not necessarily fulfill the requirement that the data protection authority is supposed to be a partner and warn you and tell you how they can, or how they imagine you should do something in a different way. The experience I made is they come, they scrutinize, and then they penalize. And that is very dangerous to the economy, I think, basically, that you as an entrepreneur, you are almost scared to move, because whatever you do can be used against you. And I believe that this regulation is taking exactly the same approach. So that at the end of the day, it will be the authorities, whoever it will be, who will tell you that you made a mistake and fine you. And what I'm missing in this draft, as well as I miss it in the General Data Protection Regulation, is that if you basically are compliant and you basically have proven that you want to be compliant, that you have a risk management system in place, and the authority still thinks it's not enough, they warn you first and give you a deadline to change things and to improve your applications before they actually issue a penalty. And GDPR and the authorities, in particular in Austria, have proven the contrary, and I fear that this approach will be followed in the draft for the artificial intelligence regulation. So this being said, and looking on my watch, it's 5 minutes past the hour, and we've used up our time. It was very interesting to discuss with all of you, and I thank the panel for taking the time to discuss here and be available for the presentations. And I would like to wish you a good morning or good afternoon or evening, wherever you are from Austria. And thank you very much for your participation.